Right, send to some analysis now. Mpumelelo Zikalala joining us now for that. Kuzeni, good to have you, and thank you very much for your time. Before we get to the nitty-gritties of what we are hearing there, let's just look back a little bit on a legal tactical strategy, right? Firstly, you have always maintained to say, well, you could have applied for bail at any moment in this process, but you chose to keep that in abeyance while you were pursuing another angle, technically, to say, well, I was extradited wrongly. So the court said, yes, it might have been an extradition that was extradition disguised as a deportation, but you gave consent, right? And that is back in court and is being challenged. But while we wait for that outcome, you now decide you want to apply for bail. Does that in any way affect all the other processes that are already ensuing?
It doesn't at all. In fact, it's a separate process altogether. Your bail application simply says, we want to ensure that your rights as per Section 35 of the Constitution is protected. Now, in order for us to assess whether you're eligible for bail, then Section 6 of the Criminal Procedure Act will then be investigated. 4 questions that need to be answered. 1, are you going to have a trial if you've got traces or past experiences that are saying to us that you are candidates that when given bail, you are likely to have a child go to another country not participated. Or secondly, they are going to jeopardize these particular investigations either through the intimidation of witnesses or concealing any evidence that is there. The status of the investigation will then come under question. What I do think will happen tomorrow is that the lawyers of Dr. Magudumana will then state that look at how far you've come with the investigation and where you are with it. Now, the chances of us going and tampering with the investigations or the tools in which we are using at this stage are very slim. So on that basis, there's no way in which we are going to deal or maybe conceal any evidence that is there. Then the third one then looks at the undermining of the criminal justice system. In this case, I'm simply exercising my rights and also simply coming back to the question that you stated earlier. Any application that I make in which I'm protecting my right, I'm available or that is available to me, it can't be taken as if I'm trying to run away from something. The only thing that is there is that I chosen at another point in another system in order to be able to utilize it, and it can't be dictated by the state as to when I'm going to apply for it. So at the end of the day, if all those 4 elements have sufficed, it is a Schedule 5 application. There are no exceptional circumstances that have been proved by Dr. Magudumana. The chances are she may be able to get the bail because we are not even looking at the merits of the matters at the moment. We are simply looking at those 4 questions that need to be answered by the court.
So is it good enough then in terms of an argument to say to the courts, well, I was instructed by accused number 5 to get into a car, and I couldn't contest because I was defenseless, I was helpless, with no one to call for help, and I complied and was taken out of the country outside of my will. I did not voluntarily depart. And then say, well, I also reserve my right to remain silent, to say any more on this at this particular point. This is all I'm willing to say.
I think from the side of Dr. Magudumana, she was saying, I want to speak at the most appropriate time, and I want to speak where it matters the most. Where it matters the most is not at this bail application stage, because they are not interrogating my innocence, strictly speaking, at this particular stage. What is being interrogated is that whether the interest of justice permits the type of release on bail. That's all in which we are going to discuss. So if it's not going to affect any public safety, evasion of trial, interference of witnesses, or jeopardizing the criminal justice system, it's something or a matter in which I'm not going to delve. However, for a better legal strategy, I must at least provide you with some of the defenses which are going to be there. And that gave us a glimpse of the type of response or the defense that Dr. Magudumana may be able to raise. She may come back and say, I participated in all those things because I was coerced to do so. I did not have any intention to do so. I feared for my life. I feared for the life of my children. So on that basis, that's what caused me to participate and act in any manner in which I've acted. So take away the element of intention, which is requisite, by the way, whenever you've been charged with certain offenses, then I must be exonerated for those things that I've done. However, from a rationality point of view, then the question would be, why don't you state those things at an earlier stage? Why do you want to endure and stay and spend time within jail by not applying for bail? Why don't you state all those cases at the start? Because you want to prove your innocence no matter what happens. So it's on those bases in which they can then come in and say, oh, well, your story may be plausible, but you need to provide some meat as you move forward. But not forgetting the very important factor. That particular defense is, yes, it is important at this stage, but not that important.
Yeah.
Where it's going to matter the most is within the trial stage. What matters the most
So
now,
why raise it at this point? So what I'm understanding you to say, this would be immaterial in terms of a Schedule 5 kind of application as to whether we give you bail or not. We'll touch on things that maybe could be material, for example, like the fact that there are other criminal cases of fraud that are currently ongoing, which I suppose could generally be material to whether or not you're going to flee the country or not. But why raise this particular matter of the fact that I was taken against my will out of the country? And by the way, I was also brought back into the country against my will, which in itself, I suppose, would leave a lot of questions to be asked.
It's that I want to play into the human element of saying that please feel sorry for me and please understand that I'm not simply submitting this bail application because I want to be out. There's a principal reason of why I participated in those particular actions. I'm not a criminal at the end of the day. My mind is not tainted enough to such an extent that it's going to engage in criminal activities. I did so not because I like to do so, but it was against my will. Further evidence and further submissions are going to come at a later stage. But I wanted to give you a further head start as to where I'm heading with this type of arguments. Strictly speaking, not really required, but it does help as a legal strategy to then say, let's tie it up together. Let's have a good story to tell in terms of this bail application so that my right to innocence, or the right that has been accrued to me, that I'm innocent until proven guilty, can now receive credibility and credence in the manner in which I'm going to say, this is the reason why I find myself sitting in this dock today.
So if you're a criminal, you're already in custody, you're applying for bail on one matter, but it emerges during that process of application that, by the way, there are other criminal cases of fraud that are currently being instituted against you. How much does that weigh for or against you in a bail application?
It depends as to the knowledge of those particular cases. Now, if I've been sitting in jail and not knowing that investigations are still carrying on, I've never received any warrants of arrest. I've never had any police individuals walking into me. At the time of drafting that affidavit, in my mind, I didn't know that certain applications or there are certain cases which are now being instituted. So in terms of being truthful and providing information to the best of my knowledge as the applicant, I'm still on the safe side. But most importantly, we must remember that unless if it was convictions that have taken place that I haven't disclosed, on that basis, the court can then come to the conclusion of saying that you are not a person who's truthful in the manner in which has been dealing with us. So we're not going to trust that you're even going to come back. We're not going to provide any credibility to the affidavit that you've submitted. But if it's the case of saying that it's only coming to my knowledge now as we're speaking that there are certain investigations which are going on, that's completely up to the state. They're the ones who are supposed to move as quickly as possible. I can't be punished for a system or a process in which I'm not in control over. But most importantly, regardless of what is happening, remember those are still allegations that can turn or render a not guilty verdict. On that basis, my right, which is the right to innocence, must be protected by the court at all costs.
Yeah. I suppose at another level, the argument to say I was taken out of the country against my will could work in advantage in terms of the flight risk question, because other experts would have said, well, the courts might look at the fact that you were already on the run to say, well, what is to prevent you from being on the run again from the law?
And in addition to that, you're on the run, and yet you're not even aware whether the certain charges have been laid against you. But most importantly, you are on the run. There's no bail application, bail that has been released on. So when it comes to the conduct of the person who is there, the conduct of the accused, you can't really impute the conduct that has taken place before I even apply bail to what is happening now in this particular point. But most importantly, there are safety measures or preventative measures that can be imposed to prevent those type of things from happening. On a daily basis or a regular basis, we hear the court saying that you are supposed to report it to your nearest police station every single day or every Friday or every once in 2 weeks. Those are the type of factors in terms of saying, well, we want to protect your right of innocence. Yes, we do. We want to make sure that justice is being served. So as a middle ground, this is what you are going to produce or what you are going to suggest to impose upon you. This is an option which is available in this particular manner. And I think the court should be justified in terms of saying, give us your passport and all your traveling documents. Stay within this particular jurisdiction. If you have to leave to another jurisdiction, you have to speak and get permission from the IO, and then report on a regular basis at your nearest police station. You fail to do that, which is part and parcel of your bail conditions, then bail is going to be revoked, and you'll be forced to spend the rest of the days up until the matter is done and dusted behind bars. It is something which is available to her. And let's remember, this is not the trial. It is simply a bail inquiry that looks into the 4 factors that you've stated earlier.
Yeah. And the state, suppose, taking an angle that wants to say this is not necessarily, for example, a truthful witness, in the sense that you are lying about your father's relationship with Thabo Bester. That degree of if it's proven that she's not been truthful around that relationship, how does that work out for her in the bail application?
Again, we would have to look at the elements which needs to be proved in this bail application. Section 60 tells you the type of questions which are being asked by the court. Now, the manner in which the relations have taken place, and when evidence is not going to be provided, which is viva voce, either from the father or from her, that says that is where the conflict is taking place, then I don't think it's going to assist the state in any manner. If the lying or the withholding of information was pertinent to the elements which are looked at as per the Criminal Procedure Act, then I would say that they've been get a fatal blow in terms of the success of this application. However, the state is simply stating things which at a later stage there can be plausible explanations of such. At a later stage they could be disputed or even not even taken into account as evidence. So if you're not going to focus on what the court is supposed to look at during bail applications, then the chances of you successfully opposing this bail application are going to be very minimal.
Interfering with witnesses, I suppose, is something else that you'd want to look at as far as the bail application is concerned, and raising a question that says, well, this is a witness with means. I mean, she promised somebody 7 million rands, so she might not directly be a threat to the witnesses, but she's got means and can use money to buy people to do things for her.
And the defense that she can come up with would to say all the witnesses which are required in this matter have been safely secured. You know exactly who those witnesses are and what you could do as a precautionary measure, even if you provide me a list. And by the way, I'll end up with a list of witnesses anyway, together with their statements, because that is what I need in order for me to prepare for trial. So on those basis, if you're not going to be part and parcel and provide and give me the benefit of the doubt in terms of being able to comply with all those processes, then I don't think we can able to move forward in a proper manner. And a precautionary measure which is used by the court in this type of application is to say, if you are in contact, whether directly or indirectly, there's any manner in which we can be able to see that you've tried to contact witnesses or conceal evidence, you must know that the trust imposed by the court to you have been broken. Your bail is going to be revoked. Any money that you have been paid will be forfeited to the state, and you are forced to spend the rest of the days up until the matter is done and dusted behind bars. That's exactly what's going to happen. So, if there's a precautionary measure that can be imposed, other than saying to a person, go and stay in jail, the court will choose or will align itself with that rather than denying bail. What are you trying to run away from? I can't give you back your time if at the end of the day you are found of innocence. So I need to find a middle ground in terms of saying, before we continue with everything else, your right to innocence is going to be protected. If there are less restrictive means that can be imposed in order for you to come back and attend trial, make sure that the rule of law is being observed by anyone. I would rather opt for that, which includes granting bail to you despite of the charges which you are facing.
Kuzen, appreciate your time. Thanks so much for coming on. Mpumelelo Zikalala there, giving us some analysis on the occurrence at the courts today.